Shalom, everybody. I came from Tokyo, where you are to visit next year for the attending of Congress. I'm also an adjunctive lecturer of psychiatry in Nara. I'd like to inform you that Nara is also a fine spot, and it's worth the visit. It's a capital city before Kyoto, and there are a lot of monuments of 8th century. Thank you. And I'd like to talk about the topic written on the slide. First, I'd like to show you a shocking newspaper. In 1982, it was 36 years ago. And please don't worry, it seldom happens in Japan. So the airplane that carried 160 passengers and 8 crew members was crashed into Tokyo Bay, as the captain intentionally retrofitted the jet in the air, and the airplane was stalled. This accident caused 24 deaths and 149 injuries. However, the captain, who was one of the survivors, was not prosecuted because of lack of criminal responsibility. He had schizophrenia at the time of retrofitting the jet, and he was occupied by the delusion. The penal code in Japan prescribes that an act of insanity is not punished, like other countries. We consider that the accusation for the behavior should be essential for the establishment of crime, and that the act of insanity lacks it. On the other hand, the Act of Mental Health and Welfare admits compulsory admission. For the compulsory admission, it is necessary to fulfill the 4 requirements written in this slide: mental disability, self-injurious behavior, or inflicting injury on others, confirmation of the diagnosis by to psychiatrists. The authority of compulsory admission belongs to the governor, not the nation. The governor, we have 47 prefectures, and each prefecture has one governor. So I'll tell you a story. When you're walking the street and someone hits you by the wooden bar and you are injured, you necessarily call for help. Luckily, the police rush to help you immediately and arrest this man. You are taken by ambulance to the hospital. And after 1 month, the police call you and tell you that he's not taken to prison, or he's not prosecuted because of insanity. Of course, you are not satisfied, even though the police tell you that a compulsory admission is ordered for this man by the governor. And after 6 months, you see this man coincidentally in the park. You should be astonished at the situation and wonder why the hospital and the governor sees the detention and allow him to go out to leave the hospital. You might want to criticize the hospital for the allowance of early discharge. However, you are barking up on the wrong tree. The hospital is the institution of treatment and is not the institution of correction. When the possibility of the self-injurious behavior and inflicting injury on others disappeared through the treatment, there is no necessity to continue the detention of this patient. And if the patient would continue the detention with that necessity of treatment, the hospital should be criticized for the violation of human rights. We can understand that the difficulty remains in time lag. Criminal responsibility should be judged at the point of criminal behavior. On the other hand, necessity of compulsory admission should be judged at the time of consultation by psychiatrists. However, there is no denying that the victim of crime should conceive the apprehension when he or she would encounter the attacker in town. Besides, in the story that I mentioned before, we cannot expect that the attacker who has been allowed to leave the hospital would go to the hospital for the continuous therapy periodically of his own will. In this background, the Medical Observation Act was enacted in 2003, and it was established in 2003 and enacted in 2005. The purpose of this act is written here: the improvement of the mental condition, the prevention of recurrence of illegal acts, and the promotion of return to society. However, the second one is the main purpose. We can understand it by the formal documents of discussion in the process of establishment of this act. The subject of this act is one who has committed serious crimes written here, but who has not been imprisoned because of lack of criminal responsibility. In this case, the public prosecutor makes an application to the district court for the court to decide if the subject should receive a real outpatient treatment or undergo compulsory admission to a psychiatric hospital. Before the court decides, the judge and the psychiatrist confer about the need for involuntary therapy, and both parties should agree that it is necessary. However, this bill of this act was subjected to strong criticism. This is, how to foresee the recurrence of the illegal act. The premise of this bill should be the prediction ability of what an individual would do in the future. Without this premise, the court's decision would be an emotional one. Regrettably, it is easy to imagine that people who have a psychiatric disorder are apt to be viewed as harmful to society. Essentially, the act contains the danger of invading human rights. And 13 years have already passed since the enactment of this act. Since 2006, as this slide shows, we have more than 300 statements of the prosecutor for the beginning of compulsory treatment every year. In almost 80% of the statements, the court made the decision of compulsory admission, and in 10%, the decision is compulsory outpatient treatment. For the time of being, it does not appear as though the public prosecutors have abused their power. It also seems that the courts adopt compulsory admission treatment prudently, as this act does have the potential to invade the human rights. However, we should remember that in the end of the 19th century, Cesare Lombroso proposed the inherent criminal therapy. Later, this theory was denied. However, even temporarily, this theory was widely approved in the world. So we can say that we are tempted to accept the theory that insists on the essential difference between offenders and good citizens, especially if a theory is armed by the modern technology and tells you that we can predict the future behavior through the subtle change on the digital brain images. I'm afraid that we are easily be persuaded, so it can be a second lie detector. Under this situation, we should remain cautious and observant about the potential for the abuse of political power for the protection of human rights. תודה רבה שהזכרתם את הנאום שלי. Next, I'd like to announce again that next year's Congress will be held in Tokyo. להתראות בטוקיו בשנה הבאה. Thank you.